compelled through the agency of this court. All decisions relied upon Puttaswamy, Navtej, Shakti Vahini, and Deepika contain broad observations with respect to individuals' choice of their partners and also a reference to non-conventional relationships. Some observations are undoubtedly to be found in these judgments that cannot be referenced to hold that a right to marry automatically flows from the manner of the provisions of
Part 3, which the petitioners assert. There cannot, for the above reasons, be a per se assertion that there exists an unqualified right to marry, which requires treatment as a fundamental freedom. We agree on this conclusion arrived at by the learned Chief Justice and his analysis of all these cases, that the Constitution does not expressly recognize a right to marry.
While we agree that there is a right, which we characterize as a right to a relationship, which is recognized in Navtej, that the queer couples and other relationships of that kind can have a union. We characterize it as a right to relationship to avoid confusion. We squarely recognize that it falls within Article 21,
as already recognized in these cases. The right to relationship here includes the right to choose a partner, to cohabit and enjoy physical intimacy with them, to live the way they wish to, and other rights that flow from the right to privacy, autonomy, and dignity. They are, like all citizens, entitled to live freely
and express this choice undisturbed in society. Whenever the right to enjoyment of such relationship is under threat of violence or coercion,
the state is bound to extend necessary protection. That is the natural consequence of this court's judgments in Navtej, Puttaswamy, etc. If it is agreed that marriage is a social institution with which the state is unconcerned, except to the limited state interest in regulating some aspects of it, does it follow that any section of the society, leaving aside the issue of rights of non-heterosexual couples, which wishes for the creation of a like social institution, or even an entry into a zone which is not popular or otherwise does not fall within the institution of marriage, can seek relief of its creation by court intervention?
In the draft circulated by the learned Chief Justice, the reasoning that there is no fundamental right to marry, and thereafter, nevertheless, to proceed to delineate the facets of features which unions other than marriage are deprived of, where it's a closer look. The summation of various rights which such couple is said to be deprived of is used to delineate the contours of the right to enter into a union
and justify a positive obligation. There cannot be any doubt that individuals have the choice of their life partners and the right to live the lives they wish to undisturbed. This is the essence of what this jurisprudence of this court has been. That is, explanation of the right to life and other rights enumerated or discovered by the interpretive process, privacy, choice, dignity, etc. Repeatedly, the decisions of the court have emphasized on the non-discriminatory and positive content of certain fundamental rights. In fact, the court has underlined the obligations of the state to create conditions conducive to the exercise of the right to equality and to realize fraternity. Refer to the decisions in Thomas and Indra Sani, which expanded the understanding of substantive equality, though without making enabling provisions enforceable by the court. This court also in some decisions accepted the argument that given the nature of fundamental rights and their evolving content, in many circumstances, it might be necessary for the state to intervene and protect the fundamental right concerned, thus creating an atmosphere conducive for the enjoyment of such right. Lata Singh dealt with honor killings of couples. In Arumugam Sirvai, the issue was virulent caste slurs and violence, which were crimes. The court required administrative and police officials to take strong measures to prevent them. In Shakti Vahini, dealt with threats by Khat Panchayats, and the court held that the state is duty bound to protect fundamental rights, and an inherent aspect of Article 21 of the Constitution would be the freedom of choice. The court issued directions.
The judgment of the learned Chief Justice propounded a theory of a unified thread of rights, entitlements flowing from it, and how lack of recognition results in deprivation of the specified rights under Articles 19 and 25, in addition to Article 21. To the extent that assertion of sexual or gender identity in exercise of free speech association to express manifestations in whatever form are concerned, one cannot join issue. Equally, if by some state process measures or conduct has been barred from expressing one's choice publicly, the reasonableness of that prohibition or order can be tested on grounds enumerated in Articles 19.2 and other grounds. However, when the law is silent and leaves the parties to express choice, Article 19.1a does not oblige the state to enact a law or frame a regulation that enables facilitation of that expression. All judgments of this court were based on effects of laws or policies based on statutory provisions. Equally, in the absence of a legal framework enabling citizens to form a particular kind of association, as for instance, recognition of a limited liability partnership, which was not recognized and given legal status till recently, the court could not have validly created the regime by enabling recognition or regulating such associations. Similarly, the absence of any enacted law which uh, enables facilitation of transport, it is hard to visualize that a citizen can approach the court and seek the construction of a road to enforce the right to travel, or seek the court's intervention to create a network of roads. Likewise, the absence of basic housing. Again, the court, if approached for enforcement of 19.1a, would not call upon the state to create one by either framing a general legislative policy or through law. Furthermore, this court has also recognized that there can be even reasonable restrictions in the acquisition and enjoyment of certain types of properties in many states. Given the nature of rights under Articles 19 and 21, the enjoyment of which are limited to the extent reasonable laws within the bounds of specified provisions, the enact in the legitimate jurisdiction of this court, it would be difficult to translate positive obligations as articulated by the learned Chief Justice's opinion. There is no difficulty about the right of two consenting persons to decide to live together, to cohabit, and create their unique idea of home, unconstrained by what others say. This is the sequitur to Puttaswamy and Navtej. Conduct hitherto criminalized is now permissible. The liberative effect of section 377 being read down is that two individuals, regardless of their sexual orientation, are enabled to live together with their dignity and also protected from any kind of violence for living and existing together. Therefore, the right to be left alone, the right to exercise choice, right to dignity and live one's life with the person of one's choice is an intrinsic and essential feature of Article 21. Even if we want to, for argument's sake, recognize an entitlement under the Constitution to enter into an abiding cohabitational relationship or union, in our opinion, it cannot follow to a claim for an institution. There are almost intractable difficulties in creating, through judicial orders or diktat, a civil right to marry or a civil union, no less of the kind
that is sought by the petitioners. Ordering a social institution or rearranging existing social structures by creating an entirely new kind of parallel framework for queer couples would require conception of an entirely different code, a new universe of rights and obligations. This will entail fashioning a regime of state registration of marriage between queer couples, the conditions for a valid and matrimonial relationship amongst them, spelling out eligibility conditions such as minimum age, relationships which fall within prohibited degrees, grounds for divorce, right to maintenance, alimony, etc.
As a result, with due respect, we are unable to agree with the conclusions of the learned Chief Justice with respect to tracing the right to enter into or form unions from the right of freedom of speech and expression. the right to form associations, along with right any other corresponding positive obligation. It is reiterated that all queer couples have the right to relationship and choice of partner, right of cohabitation,
as an integral part of choice linked to their privacy and dignity. Any further discussion on the rights which consenting partners may exercise is unnecessary. No one has contested that two queer couples have the rights enumerated under Articles 19(1)(a), C, and D, or even the right to conscience under Article 25. The elaboration of these rights to say that the exercise of choice to such relationships renders these meaningful, and that the state is obligated to recognize a bouquet of entitlements which flow from such abiding relationship of this kind is not called for. We therefore respectfully disagree with that part of the learned Chief Justice's reasoning, which forms the basis for some of the final conclusions and directions recorded in his judgment.
Agree with the conclusions of the learned Chief Justice with respect to the inapplicability of the SMA, and we also add certain observations. A gender neutral interpretation of SMA and its provisions, much like many seemingly progressive aspirations, may not really be equitable at times and can result in women being exposed to unintended vulnerability, especially when genuine attempts are made to achieve a balance in a social order that traditionally was tipped in favor of cis heterosexual men. The purpose of the terms like wife, husband, man, and women in marriage is to protect a socially marginalized demographic of individuals. For instance, women facing violence by their partner have a right to recourse under the Domestic Violence Act, which assures and is meant to assure that the victims are safeguarded and provided relief. In fact, provisions of SMA for alimony maintenance confer rights to women. Likewise, certain grounds of divorce, conviction of husband for bigamy, rape, etc., entitle the wife additional grounds. Other provisions enact separate degrees of prohibited relationships. Section 4C uses the term husband and wife. There are other provisions which deal with, which specifically used gendered terms. The general pattern of these provisions, including the specific provisions enabling or entitling women certain benefits in the effect of sections 19 to 21A, is that even if, for argument's sake, it were accepted that section 4 could be read in gender neutral terms, the interplay of other provisions which could apply to such queer couples in such cases would lead to anomalous results, rendering the SMA unworkable. It is important. Now, there is a section that deals with the discriminatory impact on queer couples. It is important to recognize that while the state ipso facto may have no role in the choice of two free-willed individuals to marry, it's characterizing marriage for various collateral and intersectional purposes, such as permanent and binding legal relationships, recognized as such between heterosexual couples only, and no other impacts queer couples adversely. The intention of the state in framing the regulations or laws is to confer benefits to families or individuals who are married. This has the result of adversely impacting the queer couples. By recognizing heterosexual couples union and cohabitation as marriages in various laws and regulations, as in employment or nominations in pension, provident fund, gratuity, life and personal accident insurance policies, for credit, particularly joint loans to both spouses, based on their total earning capacity, for purposes of receiving compensation in the event of fatal accidents, to name a few, and not providing for non-heterosexual couples results in their exclusion. The individual earned benefits by each partner or both collectively, which would be available to family members, such as employee state insurance benefits in the event of injury of an earning partner, provident fund, compensation, medical benefits, etc., are examples of what the injured or deceased partner, by dint of her or his work,
became entitled to, or the members of her family became entitled to. The denial of these and inability of the earning partner in a queer relationship, therefore, has an adverse discriminatory impact. The state may not intend the discrimination or exclusion in the conferment of such benefits or social welfare measure. Yet the framework of these policies expressed in favor of those matrimonial relationships results in denial of entitlements despite the professional abilities and contributions which the individual might make to society.
The objective of many of these laws or schemes is to confer or provide entitlements based on individual earning and contribution. For example, Provident Fund is payable due to the employee's personal contribution and status as employee. Similarly, objective entitlement of benefits of employees' state insurance, etc., flow from individual status, work, and effort.
Major part of these benefits, or all of them, flow in the event of certain eventualities such as fatal accident or death. The design of these statutes and schemes is to enable both the concerned subscriber or the employee to receive them, or in an unforeseen event such as death, for his dependents to receive them. The restrictive way in which dependent or nominee excludes their enjoyment to the intended beneficiary.
Addressing all these aspects and concerns means considering a range of policy choices and involving multiplicity of legislative architecture governing the regulations guided by diverse interests and concerns, many of them possibly coalescing. On 3rd of May 2023, during the course of the hearing, the learned Solicitor General, upon instructions, had expressed the Union's position that a high-powered committee headed by the Union Cabinet Secretary would be formed to undertake a comprehensive examination to consider such impacts and make suitable recommendations in that regard. So we proceed to agree with the learned Chief Justice's conclusions with regard to the right of transgender persons in heterosexual relations to marry under existing laws. On the issue of adoption, we express our disagreement and voice our concerns in the following manner. We have voiced our concerns and laid it out in some detail, which I do not wish to read. This is not to say that unmarried couples, whether queer or heterosexuals, are not capable or suitable to be adoptive parents. However, once the law permits, as it has done, adoption by both single individuals, the likelihood of their joining and cohabiting cannot be ruled out. In such event, de facto family unit can and does come about. The underlying assumption in the law as exists is that such unmarried heterosexual or queer couples should not adopt. It needs to be closely examined. Similarly, the needs of such couples to have and raise a family in every sense of the term has to be accommodated within the framework of the law. The existing state of affairs which permits single individuals to adopt and later live as a couple in exercise of their choice, in effect deprives the children of such relationships various legal and social benefits which are otherwise available, given the objective of to a married couple. In other words, given the objective of Section 57, the state as parents patriae needs to explore every possibility and not rule out any policy or legislative choice to ensure the maximum welfare and benefits reach the largest number of children in need of safe and secure homes with a promise for their fullest development. Response to the learned Chief Justice's comments on our draft, which I propose to read, part of which I propose to read. This court's observations with respect to the learned Chief Justice's reasoning centered around the enunciation of the bouquet of rights emanating from various provisions and locating an obligation has to be seen in the backdrop of the unanimous view of this court that the fundamental right to marry is not found within the Constitution. Therefore, it is our considered opinion that to create an overarching obligation upon the state to facilitate through policies the fuller enjoyment of rights under Articles 19 and 25 is not rooted in any past decision or jurisprudence. That queer couples have the right to exercise their choice, cohabit and live without disturbance is incontestable. In the same way that they are owed protection against any threat is the natural corollary of their right under Article 21. Consider in this context also the nature of relief sought and the positive obligation fashioned. Whilst there are innumerable judgments on the positive contents of the rights under Article 21, there are countless judgments that insist upon the separation of powers when it comes to matters of policy and the courts not being the appropriate forum for adjudication of the same. The polycentric nature of this issue is compelling. Next, as to the reasoning that our conclusion on the challenge of SME and subsequently finding on the disparate discriminatory impact faced by the queer community, a small comment is called for. The section discussing the provisions of SMA and the challenge to its validity was based upon whether it violated the Constitution on the ground of impermissible classification under Article 14, for which the object of the Act to facilitate marriage between interfaith couples, wherein at the time marriage or even a couple only denoted heterosexual couples in the light of same-sex relationships being criminalized, and its provisions are relevant factors. Classification involves differentiation. Further, this court has discussed how underclassification per se does not warrant invalidation. In contrast, in the later segment on discriminatory impact, the issue that this court was considering was not reasonable classification but impact upon queer couples through neutral laws or regulations that they encounter in their everyday lives, the purpose of which or even their substantive provisions have nothing to do with marriage. It is rather to confer other benefits, many of which are earned or accrued on account of individual skill. Yet the framing of these benefits or their intended beneficiaries were articulated in terms of entitlement to families or spouses, tends to exclude from its ambit queer couples. When such queer couples are entitled to benefits wherever they fulfill other eligibility criteria, it is the disparate impact of these neutral laws in the disbursement of entitlements or benefits which is seen through the effect or impact lens. Therefore, the discussion on constitutionality of SME is markedly different from the section on discriminatory impact in certain points for queer couples as they have no avenue for marriage like heterosexual couples. In the latter, the impact of various laws were pointed as starting point for the state to take remedial action. Be sorely mistaken if we presume what the queer community in all its diversity seeks and lays it out as a formaic framework. Many may welcome civil unions as a pragmatic first step, while some may find it yet to be another inequitable solution to the feeling of exclusion that persists in society against this community, and one which simply repackages the stigmatization felt. Many may desire marriage as understood in the traditional sense to escape their societal realities, a form of financial and social emancipation from opposing natal families, or diametrically opposite to assimilate and gain more social acceptance. Yet others may, as a result of their experience, reject altogether the institution of marriage and all the social obligations and associations that come with it, but still want protection of their rights. Certainly, what the former group may want does not hamper or hinder the latter in any manner, for it is a choice that they seek. That the state should facilitate a community an avenue for marriage. They may pass an act creating civil unions or a domestic partnership, among the many other alternatives. Another consequence may be that rather than the union, the state legislature takes actions or enacts law. What is, however, certain is that in question of such polycentric nature, whether social or political,
The court must exercise restraint and defer to the wisdom of the other branches of the state, which can undertake wide-scale public consultation, consensus building, and reflect the will of the people and be in their best interest. If, as a result of this, a law is enacted that undermines or violates the constitutionally protected rights of an individual, no matter how minuscule, their right to seek redressal from this court is guaranteed.
That the petitioners seek what many of us may deem to be normal or accepted next step in the life upon attaining a certain age, and perhaps take for granted is not lost on us. Their desire for social acceptability in the manner that has been historically known, through the social recognition that marriage affords, and the lack of which causes them the feeling of exclusion and hurt, is one that, as individuals, especially donning the robes of justice, we can certainly have deep empathy with. However, we are deeply conscious that no matter how much we empathize with the outcome sought, the means to arriving at such a destination must be also legally sound and keep intact the grand architecture of our constitutional scheme. If we throw caution to the wind, we stand at the risk of paving the way, wherein each brick wherein each brick may feel justified to untold consequences that we could not have contemplated. While molding relief as a code, we must be cognizant
That despite being empowered to see the capabilities of the law in its grand and majestic formulation, we must not be led aground because we are blinded by its glow. Now I pass on to read the conclusions and the final directions that we have summarized. The court hereby summarizes its conclusions and directions as follows. There is no unqualified right to marriage except that recognized by statute, including the space left by custom. 2. An entitlement to legal recognition of the right to union, akin to marriage or civil union, or conferring legal status upon the parties to the relationship can be only through enacted law. A sequitur of this is that the court cannot enjoin or direct the creation of such a regulatory framework, resulting in legal status. The finding in 1 and 2 should not be read as to preclude queer persons from celebrating their commitment to each other or relationship in whichever way they wish within the social realm. 4. Previous judgments of this court have established that queer couples have a right to union or relationship, be it mental, emotional, or
addressed and removed by the state. These measures need to be taken with expedition because inaction will result in injustice and unfairness with regard to enjoyment of these benefits available to all citizens who are entitled and covered by such laws. As held earlier, this court cannot, within the judicial framework, engage in this complex task. The state has to study the impact of these policies and entitlements. Consistent with the statement before this court during the course of the proceeding, the union shall set up a high-powered committee chaired by the Cabinet Secretary to undertake a comprehensive examination of all relevant factors, especially including those outlined above. In the conduct of such exercise, the concerned representatives of all stakeholders and the views of all states and union territories shall be taken into account. The discussion on discriminatory impacts is in the context of effects of the existing regimes on the queer couples. When a heterosexual couple's right to live together is not contested, the logic of the discriminatory impact faced by queer couples cohabiting together would definitionally, however, not apply to them. Transgender persons in heterosexual relationships have the freedom to and entitlement to marry. Regulation 5.3 of CARA regulations cannot be held void. At the same time, the court is of the opinion that CARA and the central government should appropriately consider the realities of de facto families where single individuals are permitted to adopt and thereafter start living in a non-matrimonial relationship. In an unforeseen eventuality, the adopted child in question could face exclusion from the benefits otherwise available to adopted children of married couples. This aspect needs further consideration, for which the court is not the appropriate forum. Furthermore, the state shall ensure, consistent with the previous judgments of this court, that the choice exercised by the queer and LGBTQ couples to cohabit is not interfered with, and they do not face any threat of violence or coercion. All necessary steps and measures in this regard shall be taken. The respondent shall take suitable steps also to ensure that queer couples and transgender couples are not subjected to any involuntary medical or surgical treatment. The above directions are in relation to transgender persons are to be read as part of and not in any manner whittling down the directions in NALSA, supra, so far as they apply to transgender persons. The directions are disposed of in the above terms.
View of Brother Ravi Bhatt, as stated in the judgment.
I am conscious of the ordeals that arise from multiplicity of judicial opinions in cases involving constitutional questions. Here I consider it worthwhile to pen the present opinion